What should you know before hiring a contingency fee lawyer? I'm Aaron Hall, an attorney in Minnesota, representing business owners in the Twin Cities area. Today I'm going to talk to you about important considerations before hiring a contingency fee attorney. First and foremost, keep in mind that this is an agreement between you and the attorney regarding how much the attorney is going to get paid. And so, as you might imagine, there's no better expert on this agreement than the attorney. The attorney is looking out for herself or himself. First and foremost, they're not necessarily trying to make sure that it's a really good deal for you. They need to make sure they're going to get paid. And a contingency fee agreement is especially crucial because the attorney might not get paid anything. Here's how a contingency fee agreement works. You've heard the commercials. If I don't get paid, or if you don't make money, I don't get paid, lawyers will say. In other words, the lawyer getting paid is contingent on you getting money. That seems like a really good deal for you. In other words, you don't have to pay the attorney by the hour. You don't have to pay some sort of fixed fee. The only way the attorney gets paid is by getting a cut of the proceeds the attorney wins. What could be wrong with that? It seems like your interest is directly aligned with the attorney. Let's look at it this way. If the attorney is getting 40% of whatever the attorney recovers, wouldn't the attorney want to get the most possible? Not necessarily. And here's the catch. Attorneys need to get paid for the time they put in. So let's say you're an attorney and I tell you you can earn $5,000 for 100 hours of work or $6,000 for 200 hours of work. Which would you rather do? Well, of course, you'd rather get paid $5,000 for 100 hours of work. Let's use a simpler example. Let's say an attorney is hired to represent you because you got in a car accident. And the insurance, after putting in 3 hours of time, the insurance company offers $10,000 to you. Well, the attorney thinks to him or herself, hey, if I'm getting a third of $10,000 after just a few hours of time, that's pretty good money. Do I really want to spend another 50 or 100 hours litigating this and maybe I wouldn't get any money? So as you can see, attorneys who work on contingency have a personal incentive to settle early and get settlements quickly so that before they put in way too much time on something. People have come to me and said, I hired an attorney on a contingency fee basis, and I don't think that attorney ever intended to go to trial. The attorney sent a couple letters threatening, and when the other side didn't settle or make a counteroffer, the attorney withdrew from representation. Now, generally that's permissible, but I understand it's very frustrating. So what other options do you have? Well, attorneys are paid in a number of different ways. Hourly is one way, or a fixed fee is another option. But many times people just say, you know what, I don't have the money to pay an attorney by the hour or some sort of fixed fee. And so that's why certain attorneys, especially in certain practice areas, are more likely to work on a contingency fee arrangement. Contingency fees are often seen in these practice areas. Accidents like car accidents, motorcycle accidents, personal or injury, class action lawsuits. You may see a contingency fee there or a fee approved by the court on an hourly basis, but it's often typically the people who are the parties in the case, the clients, are not having to pay out of pocket for attorney's fees. There are a number of other areas where you might see this as well. Malpractice might be one of those. Here's areas where you rarely, if ever, see it. You're not going to see one in bankruptcy. You won't see one in family law, like a divorce. You won't see contingency fee in criminal law. Think about it. If the attorney wins in criminal law so that you don't go to jail, what is the attorney getting a cut of? Nothing. I mean, you're by winning, You won some freedom. You didn't have to go to prison, but you didn't win money. So attorneys typically are going to be getting attorney's fees or contingency fees when you're suing for money. It's pretty clear some money is owed. And maybe there's even an insurance company, so there's some guarantee that there's a way to collect money on this. And so the big question is, how much money is owed? You often don't see contingency fee agreements in business disputes or general civil litigation because there may be counterclaims going back and forth. And so there's just too much opportunity to not get paid. So at a really high level, the reason to be cautious about an attorney's fee that's based on a contingency is you may be paying a lot more than you would if you got paid by the hour. Think about it. The attorneys are only going to do a contingency fee if they believe it's in their best interest to do that. So I'd be cautious about that before entering into a contingency fee agreement. To find out more tips and pitfalls and considerations before entering into a contingency fee agreement, contact or visit my website at aaronhall.com. There's a URL in the description below. And for similar videos like this, you can subscribe to this channel or subscribe to our email list. I'm Aaron Hall, an attorney in Minneapolis, Minnesota, generally representing business owners. Feel free to look in the description below to find out related information.